From The Australian, here's what's on the front. I'm Claire Harvey. It's Friday, November 7, 2025. One Nation has doubled its membership base since the May election and is establishing new party branches across regional Australia. One Nation's weeks away from launching a new Central Queensland branch after last month poaching National's Tamworth members to set up a base in the heart of Barnaby Joyce's New South Wales electorate of New England. That's an exclusive, live now at theaustralian.com.au. Erin Patterson waited until the very last moment to lodge her appeal against the mushroom murder convictions, and she's arguing she was the victim of a gross miscarriage of justice. Patterson has always denied wrongdoing, and now she says the trial was unfair in 7 different ways. Today, Patterson's bid to get out of jail. How does Erin Patterson say she was wrongly convicted? Well, let's count the ways. There are 7 grounds of appeal in documents lodged by Erin Patterson's lawyers with the Victorian Supreme Court. And now, of course, it's up to the Court of Appeal to decide whether or not to grant leave to Erin Patterson to proceed to the next stage. First, the court will consider the application. If it considers an appeal is justified, hearings will be scheduled. That's all likely a long way off, so it's safe to say Patterson will be spending Christmas in Victoria's toughest women's prison, the Dame Phyllis Frost Centre. Listeners to The Front will remember what Patterson's lawyer said about that prison at the sentencing hearing. This is a voice-acted exchange from back in August between Patterson's then lawyer Colin Mandy SC and Jennifer Hosking, an Assistant Commissioner with Corrections Victoria. Hosking said Patterson had access to a small, mesh-fenced yard outside her solitary cell, which adjoins her next-door neighbour's yard.
Ms. Patterson currently communicates with one other person while they are in separate yards. She does not currently physically mix with other women in the unit?
Yes, that's correct. She has approval to have access with one other prisoner. I'm not aware of how frequently that occurs, but she's certainly approved to do that.
And although she has that approval, can I suggest to you that she has never spoken one word to that other prisoner?
I can't deny that. I have no further information on that point. That could be for a range of reasons. It could be the other person or her not wishing to have that conversation.
And that other person is one of the prisoners who's been in that unit for a number of years?
That's correct.
And they are serving a sentence for terrorism offences, is that right?
Yes, that's correct.
And they have attacked other prisoners whilst they've been in custody, correct?
That's correct.
Jennifer Hosking said Patterson's cell was basic.
She has normal cell provisions, things like television, room for her personal items. I understand she's a keen crocheter and she has a lot of wool and crochet equipment in there. She has a computer which she's had for some time, and that's in her cell. She also has her own pillows. She has a number of crocheted blankets that she's made herself. She has toiletries, books, magazines. She has a hair straightener and a fan.
So it's not surprising Patterson wants to get out. But this isn't a complaint about her living conditions. It's Patterson trying to get the verdicts themselves overturned. Remember, she was convicted of the murder of her parents-in-law, Don and Gail Patterson, and her husband's auntie, Heather Wilkinson. Heather's husband, Ian Wilkinson, survived the lunch. Erin Patterson had also invited her estranged husband, Simon Patterson, to the lunch, but he declined to attend, and it was revealed after the trial that, in evidence the jury hadn't heard, Simon Patterson had previously told a Victorian court he believed his wife had tried to poison him on multiple occasions before the lunch. A jury of 12 found Patterson guilty of murder and attempted murder, and in Victoria, the jury has to be unanimous. And remember, Erin Patterson has always denied wrongdoing. She says she accidentally included death cap mushrooms in the deadly meal and never meant to harm these elderly relatives whom she loved. So here's how Patterson says she was dudded. Ground 1 of her appeal is read for you by an AI voice.
a fundamental irregularity occurred while the jury was sequestered that has fatally undermined the integrity of the verdicts and requires the quashing of the convictions and an order for a retrial so that justice cannot only be done but be seen to be done.
There are no more details in the appeal documents, but avid watchers of this matter will recall that in July, Victorian Supreme Court Judge Christopher Beale, who heard the trial and sentenced Patterson to 33 years without parole, revealed that there was an issue while the jury was sequestered to consider its verdict. Back then, the judge said the jury had been staying at the same hotel as the police informant who charged Erin Patterson, Detective Leading Senior Constable Stephen Eppingstall, and 2 prosecution solicitors. The judge said there had been no interaction with the jury. Patterson's second ground is that the cell tower evidence and evidence of death cap mushroom sightings in Lock and Outram posted to iNaturalist should not have been adduced in the trial. Patterson says they weren't relevant or the probative value of that evidence was outweighed by its unfair prejudice. That's where Erin Patterson's phone was allegedly pinging off cell towers in the same spots where death cap mushrooms had been sighted by off-duty mushroom fans who posted to this botany website, iNaturalist. The third ground is about photos and videos related to mushrooms found on SD cards at Erin Patterson's home. The judge ruled those out of the trial. Erin Patterson's saying they should have been allowed in. It's possible that what Erin Patterson's going to argue is that the judge didn't let the jury see and hear evidence of what Patterson said. She was an avid forager and had photos to prove it. Coming up, how Patterson says her own Facebook posts shouldn't have been seen by the jury. Erin Patterson's fourth ground of appeal is that the judge made a mistake by allowing the jury to hear what's called the Facebook evidence. That's where Patterson was communicating with online friends. And if you recall the trial, she was very frank in her feelings about Simon Patterson's family. Ground 5 is that a substantial miscarriage of justice has occurred because of unfair and oppressive cross-examination of Patterson. She's saying that Nanette Rogers, the Crown prosecutor, went too hard. Here's one of their exchanges from the trial, read by voice actors. This is when Patterson claimed while in the witness box that she was a sufferer of bulimia. She said after the lunch guests went home, she polished off 2/3 of an orange cake Gail Patterson had baked. Patterson said she then threw up.
Is it your evidence that the vomit was partly constituted by the beef Wellington, correct?
I have no idea what was in the vomit.
At all?
Well, how could I? It's vomit. Unless you can see a bean or a piece of corn.
Well, you didn't have corn at the lunch.
That was an example.
I suggest that you did not tell a single medical person that you had vomited after the lunch on the afternoon of the 29th of July.
That is true. I did not do that.
I suggest that is something you would have told them if it were true, correct or incorrect?
Incorrect.
Do you say it's incorrect because of your embarrassment?
I say it's incorrect because it's what happened.
Patterson's sixth ground is a claim that prosecutor Nanette Rogers caused a substantial miscarriage of justice in her closing address. And ground 7 elaborates on why Patterson says that's the case. She says a substantial miscarriage of justice occurred because even though in her opening address, Nanette Rogers had said, "We're not going to present you with a motive here, we're just going to show you the evidence," Patterson claims that in her closing address, Nanette Rogers did imply a motive. Now, the judges will look very closely at what Rogers said in that closing, but here's a snippet of it. To be clear, we don't know if this is exactly what Patterson is referring to in her appeal documents when she says Rogers implied a motive. This is a voice actor.
The evidence shows you might think that the divide between the accused and her in-laws was deeper than they ever knew. We say that the accused was leading a duplicitous life when it came to the Pattersons. She presented one side while expressing contrary beliefs to others. When Don and Gail sent the accused messages about her ongoing financial issues with Simon and mentioned praying, she replied with an eye roll emoji. She was mocking them and their religious beliefs despite attending church with them. If she did love them as she claimed, one would expect her to inquire after their welfare immediately in those circumstances. But what did she do when Simon told her that Don and Gail were in hospital? She immediately went on to talk about her own symptoms, never asked a question about Don and Gail.
Now it's over to the Victorian courts to decide if this appeal can go ahead. You can check out all our reporting and analysis on this and all the great court stories right now at theaustralian.com.au.